Hello, this is the Intellectual Property Office of Taiwan. In this video, we will talk about trademark disputes, including opposition, invalidation and revocation. What is trademark dispute system? It is a remedy system for people who believe there are grounds for refusing or revoking registration to file a trademark dispute against the registered trademark with the TPO. As shown on the screen, oppositions and invalidations are filed against the trademarks that should not be registered. Anyone can file an opposition, while invalidations can only be filed by the interested parties. Filing an opposition or invalidation against an illegally registered trademark can enhance trademark examination and verify the legality of the trademark rights. If the opposition or invalidation is successful, the trademark rights will be retroactively ineffective. As for revocation, it is filed against the trademark that is used improperly after registration. If a legally registered trademark is in any of the following circumstances after registration, anyone may file a revocation against it. 1. Being altered or supplemented with additional notes, thus causing a likelihood of confusion. 2. The trademark has not been used for 3 consecutive years without excusable reasons. 3. The trademark is not used with appropriate and distinguishing indications. 4. The trademark has become a generic mark or term. 5. The use of the trademark is likely to mislead the public. If the revocation is successful, the trademark rights will become ineffective from the time of the revocation. Now we are going to introduce the similarities and differences between trademark opposition and invalidation. Let's start with the differences. As we mentioned before, anyone can file an opposition, while invalidations can only be filed by the interested parties. As for the filing period, oppositions can be filed within 3 months from the day following the registration issue date, while invalidations can be filed within 5 years from the day following the registration issue date in general. But in particular circumstances, the filing period for invalidation is unlimited, and we will talk about it later. As for the filing fee, the opposition fee is 4,000 new Taiwan dollars per class, while the invalidation fee is 7,000 new Taiwan dollars. Now, let's talk about the similarities. Both the grounds for opposition and invalidation are the same. The following is a brief introduction to the grounds for filing an opposition or invalidation. 1. The trademark is devoid of distinctiveness pursuant to paragraph 1 of Article 29. 2. Constituting any of the grounds for refusal of registration as provided in paragraph 1 of Article 30. 3. A trademark has been revoked because it was altered or supplemented with additional notes, and the original trademark holder reapplies for registration of the same or similar trademark within 3 years from the day following the date of revocation, which is in violation of paragraph 3 of Article 65. Moreover, their legal effect is also the same. If the opposition or invalidation is successful, the trademark registration will be revoked, and the rights will be retroactively ineffective. Here are some common grounds for filing an opposition or invalidation. 1. The trademark is identical with or similar to an earlier filed trademark application or a registered trademark, and thus there is a likelihood of confusion. Please refer to the factors listed in the examination guidelines on likelihood of confusion and provide relevant evidence. 2. Causing a likelihood of confusion or dilution of a well-known trademark. Please refer to the factors listed in the examination guidelines for the protection of well-known trademarks under subparagraph 11 of paragraph 1 of Article 30 of the Trademark Act, and provide relevant evidence. 3. Being aware of the existence of an earlier used trademark and applying for registration of a similar or identical trademark with the intent to imitate. Whether the cited trademark is an earlier used trademark shall be determined according to the facts presented on the filing date of the disputed trademark. In addition, evidence shall be provided to prove that the trademark holder is aware of the existence of the earlier used trademark because of contractual, regional or business connections, or any other relationships. And now let's talk about trademark revocation. The applicants for trademark revocation can be anyone, and it can be filed at any time after registration. The filing fee for revocation is 7,000 new Taiwan dollars per class. Here are 2 common grounds to file an revocation. 1. A registered trademark is altered or supplemented with additional notes and thus there is a likelihood of confusion. The fact of making alterations or additions to the disputed trademark shall be determined according to objective evidence. For the determination of confusion, please refer to the examination guidelines on likelihood of confusion. 2. A trademark has not been put to use or has not been used for 3 consecutive years. Applicants for revocation shall specifically prove the actual time and process of field investigation at the trademark holder's domicile or business establishment, market research, inquiries and site visits of the peers in the industry with relevant evidence. On the other hand, trademark holders should proactively prove the fact that they have used the registered trademark. Always preserve evidence of use of the registered trademark in case of need. Here are some things to keep in mind when filing or responding to a trademark dispute. 1. The applicant. As we mentioned before, everyone may file a trademark opposition or revocation, while invalidation can only be filed by the interested parties. Please refer to the main points for determining an interested party under the Trademark Act to confirm whether you are entitled to file. 2. Trademark disputes must be filed separately for each disputed registered trademark. And it should be noted that disputes could be raised for part of the goods or services. 3. When filling out the application form, please refer to the notice on application and response for trademark dispute cases, and clearly state the trademark registration number, the scope of the disputed goods or services, the legal basis, the facts and the reasons. 4. The evidence corresponding to each factual claim or defense shall be numbered and presented in order, and the same documentary evidence shall not be repeatedly submitted. 5. It is important to provide relevant evidence of use to support your legal and factual claims, especially when you claim that there is a likelihood of confusion between the disputed trademark and someone else's earlier filed application or registered trademark in an invalidation case. Or when you claim that the alterations or additions made to the words, images, or colors of the registered trademark have caused a likelihood of confusion with someone else's registered trademark in a revocation case. In such cases, you shall provide evidence that the infringed registered trademark has been used within 3 years prior to the filing of the invalidation or revocation, or evidence of excusable non-use. 6. To know how to use the registered trademark correctly, please refer to the notice on the use of registered trademarks. And now we are going to introduce the application methods. The application may be filed in writing or electronically. For written applications, please use the application forms provided by the TIPO. You may refer to the application notice and application example on the TIPO's official website. In addition to filling out the application form, don't forget to attach a copy of evidence. As for electronic filing, please visit the TIPO's e-filing website, download the new electronic filing system, edit the document, and submit in the system. Lastly, here are some frequently asked questions. Question 1. If the prior users of trademarks don't register their trademarks in Taiwan, and someone else registers a similar or identical trademark in Taiwan, how should the prior users protect their rights? The Trademark Act follows the first-to-file principle. However, if the earlier used trademark has become a well-known trademark, the prior user may file an opposition or invalidation, claiming that someone else has violated the 11th subparagraph of the first paragraph of Article 30. Even if the earlier used trademark is not well known, if the trademark holder is aware of the existence of the earlier used trademark and applies for registration of a similar or identical trademark with the intent to imitate, which violates the 12th subparagraph of the first paragraph of Article 30, the prior user may still file an opposition or invalidation. Question 2. How should trademark holders respond to oppositions or invalidations? The trademark holders should explain and provide relevant evidence to support their claims. When they refute the allegations that the relevant consumers confuse their trademarks with someone else's earlier filed application or registered trademark, someone else's trademark is well known, etc., they can refer to the factors listed in the Examination Guidelines on Likelihood of Confusion, or the Examination Guidelines for the Protection of Well-Known Trademarks under subparagraph 11 of paragraph 1 of Article 30 of the Trademark Act, to respond to the issues. Also, they may run a self-check according to the self-check form for notice on defense for trademark opposition or invalidation cases. Question 3. Are there any time limits for filing an invalidation? If the invalidation is based on relative grounds for refusal of registration, which public order and social benefits are not affected or are affected to a lesser extent, it can only be filed within 5 years from the date of trademark registration. It should be noted that if a geographical indication for wine or spirits, or a well-known trademark has been registered by someone else in bad faith, there is no time limit for filing an invalidation against the mark. In addition, if the invalidation is filed on absolute grounds for refusal of registration, which involve public order or social benefits, there is also no time limit for filing an invalidation. Question 4. How to provide evidence to revoke a registered trademark that has not been used for 3 consecutive years without justifiable reasons. 1. State the actual time and process of visiting the trademark proprietor's domicile or business establishment. 2. State the actual time and process of market research or inquiries and site visits with peers in the industry. 3. Provide the relevant evidence that the registered trademark has not been used for 3 consecutive years, or other suspicious evidence of non-use. For example, if a trademark holder's company has been dissolved, cancelled or revoked for 3 years, information searched on the website of the Ministry of Economic Affairs, or other supporting documents should be provided. For more details, please refer to the Notice on Application and Response for Trademark Dispute Cases, and the attachment self-check form for Notice on Application for Trademark Revocation Cases. Question 5. What should you do if someone files a revocation against your registered trademark, claiming that it has not been used for 3 consecutive years? After receiving a notice of defense from the TIPO, trademark holders shall provide evidence to prove that their trademarks have been used prior to the filing date of the revocation. If no response is made within the given time, the trademark registration will be revoked pursuant to the Trademark Act. The evidence provided should include the disputed trademark, the date of use and the user, or other supporting documents showing that it is the registered trademark, the date of use, and information about the user, or other objective evidence that can prove the use of the registered trademark through mutual corroboration. The evidence of use provided shall be capable of establishing the genuine use of the trademark and conform to general commercial practices. If you want to know more about trademark disputes, please scan the QR code. This is the end of the video. Thanks for watching.